Who has custody of a child if there is no court order and the parents are not married and not divorced? I can answer this question as the law applies in the jurisdiction where I practice divorce and family law, which is Utah. And you may find my answer useful in conducting the research to find the answer to this question as it applies in your jurisdiction. But you'll need to consult a knowledgeable divorce and family lawyer in your jurisdiction to get the answer as it applies in your jurisdiction. Now in Utah, according to Utah Code Section 78B-15-201, entitled Establishment of Parent-Child Relationships, the parent-child relationship is legally established in Utah in the following ways. As to women, 1, the woman having given birth to the child, except as otherwise provided in Part 8 of Gestational Agreement in the Utah Code. 2, an adjudication of the woman's maternity. 3, adoption of the child by the woman. 4, an adjudication confirming the woman as the parent of a child born to a gestational mother if the agreement was validated under Part 8 Gestational Agreement of the Utah Code, or is enforceable under other law. Or 5, an unrebutted presumption of maternity of the child established in the same manner as under Section 78B-15-204. As to fathers, the parent-child or the father-child relationship is established between a man and a child by 1, an unrebutted presumption of the man's paternity of the child under Section 78B-15-204. 2, an effective declaration of paternity by the man under Part 3 Voluntary Declaration of the Paternity Act, unless the declaration has been rescinded or successfully challenged. 3, an adjudication of the man's paternity. 4, adoption of the child by the man. 5, the man having consented to assisted reproduction by a woman under Part 7 Assisted Reproduction, which resulted in the birth of the child. Or 6, an adjudication confirming the man as a parent of a child born to a gestational mother if the agreement was validated under Part 8 Gestational Agreement, or is enforceable under other law. An unmarried father has no parental rights unless and until he establishes paternity of that child. In Utah, paternity can be established 3 different ways: a voluntary declaration of paternity, administrative paternity order, or a judicial paternity order. Utah Code Section 78B-15-305 subsection 1 provides, quote, except as otherwise provided in sections 78B-15-306 and 78B-15-307, a valid declaration of paternity filed with the Office of Vital Records is equivalent to a legal finding of paternity of a child and confers upon the declarant father all of the rights and duties of a parent. Some assert that in Utah, as to a child born to unmarried parents, the mother has sole legal and physical custody of the child until a court orders otherwise, but I cannot find any legal authority for that proposition. It appears to me that once paternity of a child is legally established, as I've described above by any of those ways, that a father has the same parental rights to that child as does the mother.